Hello, everyone. I trust that you are doing well, and welcome to this presentation where we're just supporting people who are going to be writing their exam, particularly this week and maybe next week. We just want to add a few insights in terms of particularly this topic on record keeping. So this evening, I'm going to deal with record keeping. So record keeping is going to be the main discussion that we are going to have tonight. So I want us to then now discuss the key issues. So I just want to be sure about our people who are here. I just want to see. All right. All right. Okay. So I see I've got Spamandla, I've got Sisipo here. All right. So, guys, what I'm going to do is I'm just going to go straight into my presentation and give you some key insights that I want you to be aware of. There are key insights that I want you to be aware of. So I'm just going to welcome you all once again, and then you can follow us on the different platforms. Let me just share my screen now and then go straight into my presentation. All right. All right. Awesome. So let's talk about record keeping. So the first thing that I've done is I've just identified the different regulations that you need to be aware of that talk about record keeping. So the first one is the Phase Act, which is the obvious one, and particularly the requirements are in section 18. That's where record keeping is addressed. Then you've got the FIC Act, which is the FICA, which deals with anti-money laundering and anti-terrorist financing legislation. Then you've got BN 127. Then you also have got the General Code of Conduct. Then you've got Phase Notice 86 that deals with record keeping. Now I'm going to go through each one of them and give you details around what are the issues that are addressed in these legislations. So first of all, the Phase Act tells you that records need to be kept for a minimum of 5 years from termination of a product or financial service or from the rendering of a financial service. So you've got a minimum of 5 years. What records do you need to keep? Records related to premature cancellations, complaints that you received, and also you need to keep records on whether those complaints have been resolved or not. You also need to keep records regarding continued compliance with registration requirements. I thought I must do a bit of a favor for the guys who are doing the KI exam and emphasize here that all these requirements, they're just requirements, but when it comes to the KI's responsibilities, the KI is further required to ensure that these requirements are actually in place and that they're actually being observed. So, for example, the key individual has got an obligation to ensure that the FSP is complying with the record keeping requirements for the FSP. So, what that entails is that the key individual needs to ensure that there is proper record keeping of all legislation or of all requirements in terms of the license, be it the license itself, be it your adverts, be it the financial statements, compliance records. When you appoint representatives, any records, you need to ensure that you have got those records related to your compliance in place. Also, as cases of non-compliance, you need, so it happens, FSPs at times become non-compliant. For example, you find an FSP may delay submitting financial statements, or they may have not paid levies on time and they get a warning, or they get a suspension letter or something. All those records need to be kept for a minimum of 5 years, including your financial statements. You need to keep them for a minimum of 5 years because it's part of your continued compliance as an FSP. I'm not sure if I mentioned the issue of appointing reps as well. There's a lot of compliance that goes with appointment of reps. You need to ensure that you do keep records for a minimum period of 5 years, as well as any continued compliance by your representatives. Now, when it comes to your compliance, again, your compliance officers and your compliance function is required to keep records similarly as per Section 18 of the FAIS Act. So the record keeping requirements for compliance officers are exactly the same, though of course maybe the type of records that you may be dealing with may be slightly different. Now, what about in the terms of the General Code of Conduct? Importantly here, you are required to have adequate systems to ensure that you can properly keep records in terms of the financial services that you have rendered. So your telephonic conversations, as well as any other records of your clients in terms of the transactions you have had with your clients, must be kept for 5 years. Now, there is an interesting difference here. You may have noted that in terms of the FAIS Act, we spoke of a minimum of 5 years. But here we are talking of 5 years, and those two are not the same. And even in the exam, the two are not the same. So you need to know that a minimum of 5 years and also 5 years, that is not the same thing. Now, it happens at times that you advertise your financial services telephonically. You are only required to keep those records within 45 days. And thereafter, if a client has not taken up a transaction or a product, then you are not required to keep that record. So within 45 days, you keep records, but thereafter, if the clients have not taken up a product, you do not have to keep the records of telephonic adverts. So this could be in a call center setting where you're doing cold calling, or maybe somebody has been referred, and then you advertise to them telephonically and they don't take up a product. You don't have to keep those records for more than 45 days if the client doesn't take up the product. Now, record keeping as well, you are allowed to outsource. You will see later on, we are going to talk about requirements regarding this outsourcing, but you can outsource. And when you outsource, you are required to ensure that when the records are requested, they are available within 7 days of request by the registrar, by the commissioner. History has got a way of just repeating itself. Now, it's by the commissioner. So when the commissioner requests records or whatever returns they want from you, or whatever time frame. So your records will still be required within the requested time frame. So records also additionally can be kept in a soft copy or in a hard copy. So you can keep hard copies, or you can actually then keep your records maybe on a cloud. So there's a lot of technology now with record keeping. So I also thought I must mention this as I was planning this presentation. I was thinking that I need to tell you that one of the reasons why we're having this conversation is solely for you to pass your exam. So when it comes to actual practice, we go deeper than what we are doing here, because here we just want you to be prepared for the exam. But in real practice, there is more extensive conversations around record keeping, and the requirements are even way more extensive. But records can be kept electronically and can also be kept in a hard copy format. Now, there's what is called a competence register, which is a requirement in terms of Board Notice 194. FSPs must keep a competence register. Actually, FSPs need to keep a rep register and a competence register. And also they must update the central rep register, which is kept by the commissioner. But in terms of the competence register, you need a record of that. And this is the basis on which you will determine the appropriateness of your CPD programs, your any other training programs that you will do. They will be based on what your records are actually showing in terms of the competence of the people that are working in your organization. And then FSPs also need to ensure that this competence register, within 15 days of the completion of any training, this record is updated within 15 days. And thereafter, the competence register and any other related documents must be kept for not less than 5 years, which is also a minimum of 5 years. Then competence information and documentation, I've mentioned this one about 5 years, which is a minimum of 5 years. So remember, there's a difference between what we saw earlier on in terms of the General Code of Conduct. It says for 5 years, but the competence register is at least 5 years. So the wording in the exam is always very important, and we emphasize that the wording in the exam is very specific and is very particular. So that's what they're actually partly looking for. And then in some instances, other product suppliers and FSPs and even reps may request the records of their completion of class of business training, of product specific training, or other training. And this may relate to even appointment. Maybe they want to be appointed elsewhere. FSPs are obliged to confirm this to the other providers or to their product suppliers, solely for appointment purposes or for any other purposes that this information may be requested. And remember, the requirement is on the FSP, but by implication, where there is a key individual, that key individual needs to ensure that this competence register is in place. Now, let's move to operational ability. This section, I rarely include it when I talk about record keeping, but what I've done is that I've just gone out there and extracted relevant sections in terms of operational ability that you find in Board Notice 194. So, for example, you are required to ensure that you've got systems in place to keep records. Records in terms of your telephonic records, in terms of your cell phone records, in terms of your typing and documents. So I had a situation where someone was narrating to me that a certain employee resigned. And when that employee resigned, they had a company cell phone. And what they did with that company cell phone is that they deleted all the records that were on that company cell phone. So they were not sure as to what they should do with this former employee who seemingly had violated the data management policy of the company. But what I'm saying is that there is a need to ensure that record keeping is actually happening. You need to ensure that you've got policies and procedures, because this was my first question to these guys, to say, what does your policy say and what are your procedures in terms of record keeping? So it's very important, because in this case, maybe if there was a backup of the cell phone records, then it was going to be easier to access whatever records. There must also be where there is automated advice, where you are using robots or algorithms to give advice. There must be maintenance of records and ensuring that data integrity is protected. You must protect confidentiality of clients' information as well as your own information. There must be backup and data recovery. You must have a system for backup and data recovery. And there must be logical access security to data. So not everyone should be able to access your data. There must be even physical security of the data, especially where you are keeping hard copies or you are having servers which are which are storing your information, you must ensure that those servers are actually properly protected. And where you are outsourcing, and this section, just for your information, relates only to the key individuals exam. So where there is outsourcing of record keeping, you may know that it is a requirement that you must have a contract in place for you to have somebody else to keep your records or to do any other service. Whether regulated or unregulated, you need to have a contract in place. So one of the elements that must be addressed by your contracts relate to access to information and records that are kept by the third party to which you are outsourcing your services. So you need to ensure that there is record keeping also, and also that you have access to those records. And financial records also need to be kept continuously, updated monthly, and also prepared annually. And all this requires you to have proper record keeping in place. Then I move to FICA. Now, in terms of your anti-money laundering and anti-terrorist financing legislation, there are specific record-keeping requirements. There, the requirements are that accountable institutions, remember under FICA, we move away from FSPs and we move to accountable institutions and reporting institutions. So accountable and reporting institutions are required, to ensure that they keep records of the identity of their clients, the identity and authority of persons who may be acting on behalf of others, and also the manner in which the identity was established. Was it face-to-face? Was it a walk-in and you had a hard copy? Was it a face recognition? Was it a fingerprint? Was it a PIN? What was it? You need to keep record. And also the nature of the business relationship or transaction, and also the name of the person who actually collected the information on behalf of the accountable institution. And also, what were the documents that you used to identify and verify the client? And in terms of FICA, records must be kept for at least 5 years. Now, there's a difference. FAIS and FICA look the same, but there's a slight difference. What is terminated under FAIS is a financial service or product, but under FICA, what is terminated is actually a business relationship. And what is rendered under FAIS is a financial service. Under FICA, it's a single transaction. So, of course, it's both at least 5 years or a minimum of 5 years. The English there doesn't really matter, but though FICA says at least. So you must actually take note of that difference. But once you see termination of business relationship, it becomes FICA. Once you see termination of a financial product, it becomes FAIS. And then once you see a single transaction, that's FICA. When it's a financial service, that is the FAIS Act. Further, accountable institutions and reporting institutions must ensure that they must keep records in terms of the currency that was involved in those business relationships or transactions, the date on which the transactions were concluded, who were the parties to the transaction, what was the nature of the transaction, and any business correspondence. So if you communicated with the clients, or yes, with your clients, you keep records of that. And also, if you are a bank, you must keep a record of all accounts that may be linked to that particular transaction or to that particular client. So it happens in some instances that you may have a record, you may have report a transaction, a suspicious or unusual transaction in terms of Section 29. From the time of reporting, you must keep the records for at least 5 years. So so we have created about 3 requirements here. From the rendering of a business, from the conclusion of a business relationship, termination, of a business relationship, you have at least 5 years. From the conclusion of a single transaction, it's again another 5 years. And then the third one will be if you report a suspicious or unusual transaction. From the date of reporting, you must keep those records for at least 5 years as well. All right. I think that one is nicely clear. Now, records may be kept in electronic format. Records may be kept in electronic format and also by third parties in terms of FICA. However, what is very important is that where there is a third party that is keeping your records, you must ensure that there is ready access and free access by FICA, not FICA, by FIC, the Financial Intelligence Center. It must have ready access to those records. And yourself as an accountable institution, you must have ready access to those records. What happens now when you have outsourced and the third party fails to comply with the requirements? What happens? You as an accountable institution will be liable. So the accountable institution will be liable. Now, there is a further requirement under FICA that if you outsource record keeping to a third party, there are two things that you must send to FIC, the Financial Intelligence Center. You must send, firstly, you must send the name of the third party, and also you must send the address. This is like an implied thing because remember, the authority must have access to the premises and the records that are kept by the third party. So you must provide the name and also their address. And again, even under FICA, you are also allowed to keep your records electronically, or you may keep them in a hard copy. But if you are keeping them electronically, they must be capable of being reproduced in a legible format. So you should be able to maybe reproduce that record. And it must be legible. All right, then lastly, I'm going to talk about confidentiality of clients' information. You may not, as a provider, disclose confidential information about a client or a product supply. Please take note, the requirement is not only on clients' information, but even product supply information. Unless you've got a written agreement that authorizes you to disclose that information to other parties. Or you are making that disclosure in the interest of the public. Maybe you are disclosing information about a transaction that is affecting the public. Maybe there's a public interest in that matter. It could be maybe an issue where a public figure may be involved, or it could be where a public issue is actually involved. Maybe there's an accident, like I've cited the example where we had an Ethiopian airline crashing some years back, and we found the reinsurers actually came out and said, we are the reinsurers of this aeroplane, that has crashed. And I think in as much as there was an element of disclosure of public information, but there were many nationalities that were involved, many people who had died in that crash. And the issue we had a public interest. That's my interpretation of that. Maybe you might have a different interpretation of that. Or it might be a disclosure that is required in terms of law. Firstly, the FIC Act itself, the Financial Intelligence Center Act itself, obliges accountable institutions and reporting institutions to disclose information regarding suspicious or unusual transactions, and also on cash transactions up to a certain limit. So that is a legal requirement for you to disclose that information. So that information also can be disclosed if it is a requirement under a particular law. So yeah, so that does it. And that brings me to the last part of my presentation. And I just hope that you have actually gained and you have benefited from this conversation. And I'll just go to the charts and just see what you guys are actually saying. All right. Oh, I see there's a question around data security for cell phones. What measures should an organization put to ensure that information on a company cell phone have some backup? Oh, yes, I see Noreen is asking that important question. Do you know that you are now able to actually download through, obviously you may need to work with your service providers to download your cell phone data onto a cloud. So you can actually download your cell phone data to a cloud, and by so doing, that information then becomes available on your cloud, which your employees may not be able to actually delete, for example, or if they delete, you are able to actually trace it back to that particular person. But you need to work with an expert. But you can actually back up cell phone data, including WhatsApp messages. They can be backed up to a cloud, and you should be able to access that, or even any other backup system that you may be able to link to your cell phone. All right. I'll also check. Oh yes, I see. David saying here was saying something. Yeah. Thank you. So this brings me to the end of my presentation. If you have got further questions, please contact me directly, or you can just type your questions on the chat or next to the stream, and then we should be able to respond to that. And all the best for those who will be writing their exams, and for those who are using this information in their FSPs, all the best. Please bear in mind that we don't carry the liability that may arise by you taking advantage of this information. You have to consult your experts as well as your compliance officers where necessary. Thank you. All the best. Bye.